Welcome to The Upper Brand. I'm your host for today, Christine Young, and I'm here with my partner and colleague, Rich Asmus. Today, we're going to be discussing the Penn State v. Vintage Brands case. Okay, so we're just going to dive right in. We're going to be talking about ornamental use of trademarks, focusing on the Penn State case related to collegiate merchandise. Rich, can you set the stage for us? What's the issue here?
Yeah, thanks, Christine. So this really is a pretty fundamental question in trademark law, namely, what is trademark use? We see brands all the time in our daily lives, and usually there isn't much question about where to look for a brand or what a brand means. So imagine you're at the grocery store and you're looking for your favorite breakfast cereal, say, and you know where to look for that brand. You look on the front of the box. And you also know what the brand maybe on the top left of that box means as well. That's the house brand of the manufacturer. And you would never think that a name in either of those places was ornamental or somehow did not function as an indicator of source. And we'll talk about this later, but you might have a different view about maybe some kids movie that's referenced on the back of the box. You probably don't think that that is a source identifier for the brand of cereal or the manufacturer of the cereal. And this same analysis applies to lots of other common goods. Like if you were out in the market for, say, a men's undershirt, and you wanted to know what brand you were buying, you might look at the hang tag in the store, or if it was a shirt that had already been purchased and the hang tag was no longer on it, you'd look on the inside tag of the t-shirt. That's all very straightforward, but not every brand use is like that. So I'm an F1 fan, and as you may know, F1 cars are just plastered with different brands, and often in places where TV viewers can see them very clearly. So, for example, when the race cuts to the driver perspective, viewers see several prominent brands pictured in that view of the car. But what's going on there with those brands? No one really thinks the F1 car is made by one of those brands that the viewer sees. And maybe even no one even thinks that the team itself is run by that brand. People know that those are sponsorship arrangements where a brand is paying F1 or maybe the team to place their logo on the cars so that everyone will see it.
So how did this come up in the Penn State case?
Penn State, a university in my home state of Pennsylvania, has a big business licensing merchandise for sale. So if you go to the Penn State University bookstore, you can buy a hoodie with a Penn State logo on it or a Penn State hat or what have you. Penn State's obviously a huge sports school. In this case, one of the defendants was a company called Vintage Brands. And what Vintage Brands does is it takes old historic designs of university mascots and names and logos. And when I say historic, I mean some of these in this case from the 1920s, from the 1950s, and they actually look quite old-fashioned. It takes those historic designs and it makes them available to consumers on merchandise, shirts, hats, coffee mugs, that kind of thing. So you can go on Vintage Brands' website and order a t-shirt with, or you could, I should say, and we'll get to that, get a t-shirt that has a logo from the Penn State Nittany Lions from, say, the 1920s. And as you might imagine, a university like Penn State that is a lucrative merchandising business doesn't like it when there are competitors out there that it hasn't authorized. And to be clear, Penn State did not authorize this at all. It has a program to authorize manufacturers of clothing and other merchandise and licenses them to use the Penn State name, the Penn State logo, and all the other trademarks associated with the university and its football program or other sports programs. And they did not license the defendant Vintage Brands here. And in 2021, they filed suit against Vintage Brands and several other parties in the Middle District of Pennsylvania in federal court.
So how is this all resolved?
Yeah, so this case was, as I said, was filed in 2021. So at this point, about 4 years ago, and it's actually still very much going on in various ways. So it went through discovery. There were some motions to dismiss. There was actually a summary judgment ruling that was pretty interesting in February of 2024. But ultimately, the court let a number of claims go to the jury. And it was a closely watched case for that reason. And the jury came back in November of 2024 with a verdict for Penn State. It awarded a relatively modest amount of monetary damages, but the important part for Penn State was that it found infringement, and Penn State used that finding to seek a permanent injunction, which the court actually went ahead and ordered just last month. It was June of 2025 that the court entered an injunction prohibiting Vintage Brands from offering merchandise with these historic Penn State logos on it.
So not a great outcome for Vintage Brands, whose business is sort of centered around this whole model. Is Vintage Brands appealing?
Yeah, so we're still in the district court. I certainly think an appeal is quite likely. After the permanent injunction was entered, Vintage Brands has submitted, in fact, just in the matter of the last couple weeks, a motion for judgment as a matter of law, or alternatively, for a new trial. They interpose a number of different defenses. One, that they say the verdict form is confusing. There were, as I mentioned, several different defendants, and the jury answered yes to infringement for all of the defendants, except in one of the cases, they have a different answer. So yes to one and no to the other, which kind of doesn't make sense in this particular case. And so Vintage Brands is saying that reflects some real confusion in the verdict form. They also allege that the jury was improperly instructed to consider not just point of sale confusion, which everyone agreed was at issue, but so-called initial interest confusion, as well as post-sale confusion. They have two other things which I think it's worth talking about a little bit more. They claim that it was not trademark use at all, and they claim that the designs were aesthetically functional, sort of a defense that we talked about in a previous episode of the podcast about aesthetically functional uses of a trademark.
So why is this so important to brand owners?
Yeah, so as you can imagine, the collegiate licensing business is a big one. Lots of people have merchandise from their alma mater that might show their university's name and logo. My kids are one in college, one getting there, so we go on college trips, and oftentimes they'll go to the bookstore and get some merch of some kind. So it's a big business, but not just for colleges and universities. But if you think about any brand owner that has a merchandising business, and you think about what they sell, well, often they sell clothing, let's say T-shirts or hoodies that have their brand sort of plastered across the front of the shirt, on the chest of the shirt. And the question is, going back to our examples of a cereal box and the movie stuff on the back of the cereal box, or a sponsorship that might appear on an F1 car, is that trademark use? In other words, do you think when you buy a university emblazoned T-shirt or hoodie, do you think that means that the source of that T-shirt, let's stick with T-shirts, do you think the source of that T-shirt is the university? And probably you don't. In other words, you don't think that the university actually manufactured the T-shirt. You think that the university sponsored or authorized the use of that T-shirt. In other words, that the university is a secondary source of the T-shirt. Let me pose that question to you. You're out visiting a university and you go to the bookstore and you see the hoodie. Do you think that because the university's name is on that hoodie, that the university is actually the manufacturer of the item of clothing?
From my perspective, no, I would not think that the university is actually manufacturing hoodies or T-shirts or any of that merchandise, but that hopefully what's being sold on their campuses and around their campuses and elsewhere in the marketplace are licensed merchandise. So that I would think that the university has given some permission for some other party to manufacture and sell those goods.
Right. And what you're describing is what the courts sometimes call as the secondary source of the good. In other words, people know that the T-shirt isn't actually literally manufactured by the sponsor of the T-shirt, in this case, a university. On the other hand, if you went to the bookstore and you picked up one of these hoodies and then it fell apart, after 2 wash cycles, who would you be annoyed with? Well, you'd probably be annoyed with the manufacturer of the hoodie, but you might also be annoyed with the university that put its name on that hoodie. So I think, that's one way to think about why this case might be so important to brand owners. Even when that brand owner is acting as a secondary source of a good, when its trademark is emblazoned on the clothing, consumers might well be angry at the brand owner. It might cause the brand owner some harm to the value of their brand if those goods were shoddy.
Very interesting there. And especially because consumers are sort of used to, they understand, I think, generally the concept of licensed merchandise and oftentimes pay a premium when they know that they're getting something authentic. So I think the price point, too, is something of importance here and possibly relevant.
I think as trademark lawyers, which obviously we're not your normal consumer, but there's an element of free riding that we don't like in a case like this. In other words, any university has built a reputation over many years, in Penn State's case, over a century, decades of investment in the brand. And somehow I think we probably see these types of merch uses as sort of free riding on that. It's clearly an important case for the defendant as well. Part of their business model is taking these vintage images and putting them on T-shirts. And not just universities, but other things as well. And so really for every brand owner, it's important how this case turns out. So there'll be a number of things to watch out for in this case. We expect to get a decision on the Vintage Brands motion for judgment as a matter of law, or in the alternative, a new trial. Of course, it's always possible the case will settle at some point, but probably not. And then ultimately, there might very well be an appeal to the appellate courts on this. And ultimately, it's certainly possible that this case could go to the Supreme Court. In fact, in the briefing on the motion for judgment as a matter of law, they actually cite to two recent Supreme Court decisions that sort of went to this issue, one being the Jack Daniels case that we've written about before, about parody. And it really all comes down to this fundamental issue about what's going on the front of a T-shirt or on the front of a hoodie when you see a brand. In other words, is it like the front of the cereal box, or is it like the back of the cereal box, or is it something in between? There's really quite a sliding scale of what constitutes trademark use and what doesn't.
And if this case does ultimately go against Penn State, I would think that that brand owners would see a significant risk to certain revenue streams and the ability to license their marks. I mean, if parties like Vintage Brands or others are able to freely use trademarks in what you might call an ornamental fashion, or something that's borderline an ornamental fashion, I would think that would cut off the incentive for parties to do deals with brand owners for certain merchandise and to potentially have the ability to cut off significant revenue streams.
I mean, we're talking about collegiate sports here. This could apply to the professional sports context. Really any place where a brand owner is deriving significant revenue from merchandise sales. And what do we mean by merchandise sales? We mean sales that aren't related to the core goods of the brand owners. Obviously, Penn State's core goods is education. It's a source identifier for an educational institution. But clearly part of the economics of college and university sports is these merchandising revenue streams. But it could apply really outside the sports context, really in any place where the brand owner has some significant non-core good revenue streams where their brand is being used not as the primary source indicator of the good, but as sort of a sponsor or, somehow affiliated with the use.
Yeah, that potential broad impact makes this case really one to watch and follow as it makes its way through the courts, on appeal or otherwise, or settlement. The parties may very well reach a settlement agreement ultimately. Thanks, Rich, for all of that insight. And if anybody has any questions for future episodes on trademarks, licensing, or brand success, please email us. You can look us up. Thanks for joining us on The Upper Brand, and see you next time.